Hopefully you can see the front page of Moodle.
Yep.
Yes.
Thanks very much to everybody for coming online tonight. I'm conscious it's a very busy time of year for everyone. I've marked, first thing I wanted to say is I've marked and uploaded all the assignment results through Moodle. I looked before and it's showing that there's no outstanding ones to be done. They're all done from my point of view. You can imagine that took me a bit of time, but it's obviously a very important process because I'm very conscious of the amount of effort and energy that each of you has put into that, and it consequently was deserving of careful review, and I hope, but more so than anything else, I hope that there was some positive stuff that you took out of it. That is that from your point of view, it was a positive learning experience. It was challenging. It was intended to be challenging, but that the challenge was genuinely about learning and improving the process, and that it didn't, and that was a positive thing for all of you. So that's the first thing. The second thing I wanted to talk about was our schedule over the next couple of weeks. What I'm intending to do is that our next live session will be on the 8th of January. So next week, Thursday next week is Christmas, of course. The following week is New Year's. We'll have a live session on the 8th. Between now and the 8th, I will record another session. So it won't be live in the sense that you guys won't be there, but I'll do exactly what we normally do in the sense that I'll work through things. We just won't have the interaction component in the same way. But what I'll, of course, be doing in the remaining weeks of the course is we won't just have one session in all of those weeks. We'll have a number of additional sessions. There'll be one additional session about which I do, which is a recording I'll do about the examination in length. We'll have an additional Zoom session together, an interactive session, a live session, if I call them that, where we are spending as long as we need to as a group on talking about exam type questions that you might have for me, quite apart from the things that I'll talk to you about in the recording in terms of the examination. At least those two, and if we need others, to pick up questions that you might have in addition to our normal scheduled classes or scheduled Zoom sessions, if I call them that. All right, so let's have a look at this week's materials, starting with, and you can see we're still on this idea of really looking at similar concepts, or looking at the concepts, but looking at them in a way that effectively picks up the idea that we're doing the same thing, but we're looking at it from a different perspective. So much of this stuff, as it was the case last week, a lot of this stuff, when I read it, I think it feels a little bit repetitive at times, but it also feels like we're adding. So we're adding, with a little bit of repetition, we're adding additional materials or additional information the whole time. If I can't speak today, it's because I've been in a hearing, so it's funny how you lose your voice. Intrinsic. So let's talk through these key terms. Intrinsic. We've used the phrase or the word extrinsic a lot already in the course, and particularly in the last couple of weeks, extrinsic was a key word for us because and you'll see it's mentioned there down in the introduction. But here we're looking at material within the Act, this idea that elsewhere in the Act there might be something that really assists us in interpreting the specific section or the part of the section that we're looking at. So I'm always thinking about where is this what else is in this section? Where is this section positioned within the Act? How does this part or division of the Act work? Are there other miscellaneous provisions, definition provisions, etc., that might impact upon this provision? So really considering the Act as a whole. One of the challenges with the intrinsic mechanism that they're talking about here, I think, is that as time has gone on, acts are larger and larger. And what that means is that you can potentially miss a provision or provisions which are relevant to the question that you're being asked. And that I think is very difficult. You might remember, and I think we've spoken about it before in this class, the case involving the Chief Stipendiary Magistrate of Queensland, who went to prison because there was a breach of an offence under the criminal code relating to a witness, and the witness was another magistrate, if my recollection serves me correct. But the issue that went to the High Court in that case was a single provision at the end of the Magistrates Court Act, which gave an administrative protection to the Chief Magistrate. And so the High Court effectively overruled the lower courts on this new point. But it was an excellent example, as I think we've spoken about in the past, of something intrinsic within an act which is very, very important in terms of the context of the interpretation of other provisions within the act. Something that might be hidden at the end, or it might be there, but it's so difficult sometimes to pick up those different parts. Leading provisions is the idea that different provisions within an act will have more importance or less importance than other provisions, and how provisions within the same act that might potentially seem contradictory need to be synchronized, if I use that word, that there needs to be some type of checking process whereby you give them priority over one or the other. Preamble, well, we don't see preambles that much in Queensland legislation, but it's the idea that at the start of the legislation there's a clear purpose. We tend to see an objects clause or an objects section often in Queensland Acts, but a preamble, there's been much talk about a preamble for the Commonwealth Constitution, but a preamble is a bit like an objects clause. It's an overarching statement of the purpose of the Act. Why is it here, etc. There was talk about the Constitution of Queensland Act 2001, Queensland Constitution, having a preamble added. And I think it was added in the end, but the wording was tinkered with for much time. Short title or long title as opposed to a long title. A long title of the Act might be the Central Queensland University Act or something like that. The short title might be CQU Act or Central Queensland University Act without the etc. So you'll get different. I remember the reason I used that example. I remember many years ago at the University of Queensland, they were going to amend the University of Queensland Act, and it became a big issue because the parliamentary drafts person wanted to take out the at the start of the Act, so that the Act was called University of Queensland Act U, starting with a U, as opposed to a T, because they thought people won't be able to find the Act if it starts with a T. And that's a good example of a long title as opposed to a short title. So we're really looking at this idea of intrinsic material, and the first thing is this idea of leading or subordinate provisions, prioritising specific provisions within an act or within a part of legislation. This is difficult because one of the things the courts have always been very focused upon is not, and you might remember we were talking about reading down or reading into legislation things. Reading down is just to keep the focus on the words that are there and not to give them an expanded scope. Reading in is not to add words. But what we're talking about here is this idea that you shouldn't delete mentally or in an interpretation sense, delete words from the legislation. You need to give effect to all of the words. And of course, if you're giving effect to all of the words, you're giving effect to all of the sections. And that becomes difficult because, of course, there'll always be the potential with a specific set of facts for there to be some contradiction. Last week I used the example of a contractual clause, and that's the case here. There'll always be the potential for there to be, as there is in any legal drafting, for there to be some contradiction between specific provisions in a piece of legislation or in a contract, etc. What often is the case, though, is that there will be some indicator of what the part, etc., is about. Yesterday, I was asked about a tax question, and the question involved, I'll try and remember it now because it comes into mind as I'm reading this. It involved a superannuation contribution, and the question was about whether a certain type of contribution created a reportable superannuation contribution in accordance with the tax legislation. Now, one of the provisions that I was asked about was in a part, and when you looked at that section itself, the section seemed to be applicable. But when you went back to the start of that division of the tax legislation, it said this division applies in these specific circumstances. And this case, well, these facts that I was asked about were not one of those circumstances. And it was a good example where a particular part or a particular division of an act may seem to have applicability, but in fact, it's not applicable. So you can't, and that's that very important point of picking up where is this section in context with other parts or divisions in the Act. It's I don't think that when I read a piece of legislation, and the first thing I always try to do is I don't read it from front to back, but you certainly read the table of contents quite carefully to get a feeling for how the Act has been drafted and to put in context how the Act works. And at least that gives you an overarching sense of how the Act has been put together. It might have provisions about what the Act's about. It might have some initial sort of introductory provisions, and then it might talk about key things. Then it might set up a tribunal or a set of appeals to a court or a set of appeals to a chief executive, etc. And then it might have miscellaneous provisions and maybe transitional provisions at the end. So you get a sort of a sense for the contents of the Act. But when I read those contents, I'm never thinking, gee, that area is more important or less important than another area. My initial reaction is to say, all of these sections are important. Which ones are important in the context of the facts, the material facts, which I've been asked about? So when they say leading provisions and subordinate provisions, I'm thinking, I'm not tending to use those words leading and subordinate. I'm using the thought process, which ones are the ones that I need to focus upon in terms of my material facts, and which ones are less important in terms of the facts that I've been asked about. They give an example of a High Court decision, Project Blue Sky, in the Australian Broadcasting Authority. There they needed to look at specific legislation and ask, well, which parts of the legislation were more or less important? And they talked about having to reconcile conflicting provisions, or provisions which seem to be conflicting. When the reality is at the end of that process, they will identify which provisions they think are the important ones or the correct ones in terms of the facts in question. And that I think is the focal point in terms of what you should take out of this section. Part of the Act or not. So it's important, of course, to remember that we're effectively being judicial in the way that, what I mean by that is we're thinking in a judicial way. We're interpreting what the legislature have put in place. And if we aren't certain about it, one of the things we can do, of course, is go and ask a judge for a declaration, potentially, as to what the provision actually means in our context, a declaration. So we need to think about, whether or not something forms part of the Act for the purposes of our interpretation. So the sorts of things that I'm thinking about are the schedules to the Act, the headings within the Act. Are they part of is the heading part of a section? Are notes, at the end of a section you might see a little notation or an example that might be given at the end of a section to help someone understand what that section means as a person reading that section. Are these things actually part of the Act? And therefore, do we need to take them into account when we're doing an interpretation of a specific provision? And they give an example here, or they just put in Section 13 of the Commonwealth Acts Interpretation Act. All material from and including the first section of an act to the end. If there are no schedules, then the last section. If there are one or more schedules, the last schedule, i.e. the schedules are included. And think about all the different things that can be included in schedules. You can have, I think about costs. They have all these schedules about costs in our procedural acts for the courts. You see also they mention there that the long title, the preamble, the enacting words. So the enacting words might be, by in accordance with or by the grace of God and Her Majesty Queen Elizabeth II, in accordance with the signed at by the Governor General, in accordance with the signed manual on such and such a date, such and such a time, this act shall receive royal assent by virtue of, there might be a whole series of enacting words, and they used to be very traditional words, a bit like the sort of words that I've just used there. They're a little bit less formal now in the way they're done, but they're still enacting words for the purpose of the Act. Headings are, in the Commonwealth sphere, included or part of the Act. So in the Commonwealth context, at least, by virtue of Section 13, pretty much everything that constitutes the Act is part of the Act, and therefore is something you need to take into account for the purpose of interpretation. And that's something I think that's changed over time. Traditionally, things like headings or notes or schedules were not necessarily considered to be part of the Act. They were there, they might have some impact legislatively, but in terms of interpreting the Act as a whole, they weren't necessarily a part of the Act. And so this modern concept that everything that is there is there and included by virtue of the Acts Interpretation Act is an important one. And what it means is that if there's a specific phrase that might be used in the heading to a section, you need to think about that phrase, or particularly if it's the heading to a division in an act. And if you just spend a little bit of time, just 10 or 15 minutes on the Queensland legislation website or on ComLaw, the Commonwealth legislation website, you'll get a feeling for this, that division headings in particular really set a context for the whole division within an act. And they will then sort of permeate the way you'll think about that division. So the long title is what I would describe as the formal title to an act. That is I remember visiting a college in England. One of the colleges at Cambridge is called Jesus College, but its real name is not Jesus College. Its real name is the College of the, I don't know it off the top of my head, but I think it's something like the College of the, Immaculate Conception, the 12 Apostles, Mary, Joseph, and Jesus. And so its short title is Jesus College. Its long title is a very old historical title that links to when it was a monastery or something. But I always think of that as an example of how we use short titles all the time. It's important to think about the long title and to remember that it is part of the legislation. And that's important because the long title itself may be a clear indicator of an indicator of the purpose of the Act. And look at the Australian Human Rights Commission Act. I mean, people might call it the AHRC Act, etc. But think about what that's saying, even in its long title. And they make the point here, and for related purposes, and how that might play out in terms of the additional things that the Act might have. One of the things I always find amazing is when you look at some of the original Queensland legislation, and I had cause to look at it because I was looking at some native title issues. I remember, this is quite a few years ago now, but I remember in the late 1890s, early 1900s, the first Queensland Act that related to Aboriginal affairs, I think from recollection, was called something like the Aboriginal and Opium Act. So it was actually two radically different purposes stuck in the one piece of legislation to, sort of regulate and outlaw and control opium trade or drug trafficking effectively within Queensland, and then something also to do with Aboriginal affairs. And so it's interesting that the title of the Act, even the long title as that Act has, can give a very clear indication of the purpose of the legislation. Short title, of course, simple, allows for the colloquial usage, the daily usage, allows for the Act to be cited in an efficient way. I mean, if every time you had to refer to the Australian Human Rights Commission Act 1986, open brackets, Commonwealth, close brackets, then that becomes, you're doubling the length of your document, whatever's type of document it is, pleading, advice, submissions, etc., by virtue of the title. So you just want to simplify that in some way, and a short title in the Act has the same purpose as an abbreviated title might have in your pleading or submissions, etc. And they just give an example of another Justice Kirby example from the High Court. The preamble, as I mentioned above, and as they say there, it's not that common now to have a preamble. it's commonly the case that you'll see an objects clause. And it's the older pieces of legislation that will have the preamble. The great worry traditionally with the preambles has been that they're seen as being almost like a dominant purpose for the Act, and that they have an overarching dominant impact in the way provisions are interpreted within that legislation. A purpose that's overarching and above and beyond what might have even been the intended purpose created by the legislation, or created by the legislature, I should say. And so there's been a reluctance to put longer preambles. So they'll have a short objects clause that might articulate a very simple purpose, but not some long preamble or longer preamble. And preambles did tend to be a little bit longer than what we now think of when we think of an objects clause or an objects section. Objects clauses tend to be at least in the Queensland drafting sense, relatively short, 2 or 3 or 4 lines. They set out what the primary reason, I would describe as the reason for the existence of the legislation. An act to provide for land sales in Queensland and the mechanism by which they will occur. I'm just making that up, but what I'm saying is it's often quite succinct relatively, and it doesn't really fundamentally change. I mean, we've got an idea about why is this act in place, a reason for the act to exist, but it's not going to change or play with the interpretation we might give. And it certainly it won't create arguments that allow different provisions to be interpreted in a different way, if that makes sense. If you go onto the internet and you read about the European Convention on Human Rights and the way it impacted on the interpretation of English statutes, you'll see that's something that I think has been considered, or that type of impact of some sort of overarching preamble type provisions, the way those provisions have impacted upon the interpretation of English statutes, I think is the sort of thing that has been carefully looked at in terms of the way objects clauses, say in the Queensland legislation, are quite succinct. I won't say they're simple, but they're efficient in the way they're drafted. And they give you some more examples here. I mean, obviously the courts will look at the objects clause, and you'll find judges will when they're working their way through an act, will look at the objects clause and will, but of course then also look at the second reading speech or the explanatory notes. But you'll find that the objects clause will be something they'll refer early on when they're going to work their way through an act, and then if they're uncertain or there needs to be further extrinsic material looked at, they'll look for the second reading speech or the explanatory notes, etc. Even just before we started this session, I was looking at the Building Construction Industry Payments Act, which I think on the 15th, what's today, the 18th, on the 15th, the new amended act came into force. And I haven't looked, for example, to see whether there's been any changes to things like the objects clause in that act. I don't think there has. They've tinkered with some of the internal mechanisms within the act in the way it's been done. Definition sections, I think, are more and more important. And one of the great dangers is to miss a definition. And you'd think, well, that's be very difficult to do that, difficult to miss a definition. But in fact, I think it's quite easy to miss a definition. What happens is that they'll say a phrase, and the phrase might be, I'll try and think of an example. the monetary jurisdiction of the court in equity. That might be the phrase, monetary jurisdiction of the court in equity. In the definitions schedule, and often there's a section, and right at the start, and it says the definitions to this act. So it might be section 4 of the act. The definitions to this act are in schedule 1 to the act, and then you go down to schedule 1. Now in schedule 1, it'll have a definition for court. It might have the example I gave you, the monetary jurisdiction of the court in, in equity or something like that. So it might have a definition for monetary jurisdiction. So that phrase, monetary jurisdiction. It might have a definition for court. It might have a definition for equity. Maybe it won't. But then it might also have, in addition to that, a definition for jurisdiction of the court for that phrase. And that's where I think it can, that's what I say when I mean, that's what I mean when I say you can sometimes miss the definition. So there'll be a long phrase with 6 or 7 words in it. Some of the individual words might be defined, and then you might have a definition for the phrase, or for a phrase within that phrase, if you know what I mean. And so you've just got to be very careful to pick up those different intricacies, and they might then change the way it's defined. And that then needs to be interfaced back up with the specific section that you're looking at, and how that then, plays out. And I remember many years ago being asked to look at a question involved, I don't know why I thought of this at this moment, but I was asked to look at a question of a construction of a swimming pool in northern New South Wales. And because it was in New South Wales, and I was being asked to look at it from the construction company's point of view, I remember all of the legislation for me, I was looking at it for the very first time. I had absolutely no connection with any of these acts before this point in time. So I was going through the process, as we often do, as you do, as I do, of considering the provisions without any preconceived notion of how they work or how they all fit into place. And I just remember it in the context of thinking about, all the different definitions and how they might interface with the interpretation of the specific words and phrases in the section. And they just give an example here. You can see of the different phrases. And there's a good example, Aboriginal person, and that might be defined separately from person, let's say, or affected person. And so you need to be very clinical about the way you look at those different definitions and how they might all interface. And that might be an example where you need to be really careful about which one is going to be dominant in your factual circumstances. And hopefully there isn't a contradiction in the way they've been drafted. Section 32AA, definitions generally apply to an entire act. The good thing about Queensland legislation now is that if a definition only applies to a division or a part or a section of the act, it will normally be within that division, part or section, and it will normally state that quite clearly. And then the generic definitions, if I call them that, will be all together in a schedule. And that's certainly the case now for the Queensland legislation. I can't think of any exceptions to that, even amongst the older legislation, because they've tried to create a consistency in the way it's all been done. The challenge, of course, is when you move into another jurisdiction and some of those drafting consistencies aren't necessarily applied or aren't the case. And particularly where you move out of the Australian realm now, you start to see very different Solomon Islands, PNG, even New Zealand, that sort of Pacific Rim of common law countries, all using an English-style common law system, but you do get older style legislative drafting or just legislation that's been in place for a long period of time and hasn't been amended in the same way. So just be careful of that. Now, they just give an example of they talk about Kelly and the Crown, Kelly and Regina, standing for the Queen or the Crown, which means it's a criminal case from 2004. Justice McHugh, functioning of a definition is not to enact substantive law, it is to provide aid in construing the statute. So that's an important point that His Honour makes there, that the definitions aren't supposed to in themselves provide substantive rules, regulations, breaches. I'm doing a function at the moment, or I'm fulfilling a role I'm reviewing the action of some lawyers. And in that, I won't say too much about the detail of it, but all I'll say is I had cause in fulfilling that role. I had to check, of course, the Australian solicitors' conduct rules and their applicability to the actions of these particular lawyers in terms of the report that I am providing. And one of the issues that came up there is that the phraseology that's used in the definitions, or the glossary as they call it in those solicitors' conduct rules, those phrases are then picked up in other parts of the rules. But there's also a preamble or an objects clause at the start. And in fact, it's in that objects clause that there's really the key thing that might be an issue here. One of the things that might be an issue comes from the preamble. And so it's this point: do the definitions or the preamble, are they substantive law? Do they create substantive questions? And are they something that therefore impacts upon the other parts of the rules in how they're interpreted, or do they have their own effect? Are they binding and create, binding rules or breachable rules themselves? And that was something that I needed to consider in that context as well. Exhaustive or non-exhaustive. So this is the idea of, this idea that a definition might say animals includes, and we'll learn more about this in coming weeks, of course, animals includes dogs, cats, and other animals, or something like this, and other pets. So it might very much be a non-exhaustive definition. Now, we're going to learn rules about, well, what's the impact of identifying dogs and cats, etc., and those additional words at the end. But the point being that it's not an exhaustive definition. It's a non-exhaustive definition. It's just giving some examples, and then there are other types that can possibly be included in the definition. So includes is a non-exhaustive definition, means limit is intended to be an exhaustive definition or a limiting definition. And in fact, that's exactly what I was just saying. We're going to learn more about the justum generis principle, or the justum generis mechanism for or rule for interpreting those types of definitions in due course. Now, headings, this is the point I was making before about there not only has there traditionally been a difference, there remains a difference between the Commonwealth and the states in terms of how headings are viewed, and not just headings within a section, but within a part or a division or a chapter, however so titled, and whether that's part of the legislation. As we saw before, Section 13 does make it a part of the Commonwealth by virtue of Section 13 of the Acts Interpretation Act. It is a part of the Commonwealth Act. It should be interpreted as such, but you just need to be careful, because certainly traditionally and in some of the jurisdictions, you would want to be checking to make certain that the heading is part of the Act for the purpose of the interpretation of it. Schedules, now normally they're always part of it now, but once again, that's another thing you want to be careful about in terms of whether it's part of the Act for the purpose of interpretation. Notes, they're called notes, but when I think of them, they're often like an example or an explanation in some way of what it's meant. Now, I haven't seen a margin note or a head note or a footnote for many years in Queensland legislation. In fact, I can't recall seeing one now for a long, long time. What you see in the Queensland legislation is within the section or at the end of the section, little smaller font, italicised, a note which just gives you a little example of what that section's intended to mean or how it's intended to work. And it's interesting that in the Commonwealth sphere, as they mentioned there, these are now part of the text. They're part of the Act for the purpose of interpretation. And this is really the becoming more and more the norm or the standard. That is, if it's there, it's part of it. This old idea that they could exclude parts or headings or notes or schedules, etc., preambles, etc., is I think a gone concept or a bygone concept. That is, if it's there, you interpret it. It's part of the Act. Is really the way it's heading. Punctuation. I think I mentioned to you a few weeks ago the example of an interpretation of a will, and I was in the court, and we were talking about a number of things in a specific clause of a will that had an impact upon the interpretation of the clause. I mean, it was in that sort of what I'd describe as an older English style of drafting this will, and there were a number of commas, which is why I'm thinking of it here in terms of punctuation, that the punctuation can have an impact upon interpretation. And you do need to think about what impact the punctuation might have. And of course, you need to take into account that where there is punctuation, you need to work on the assumption that Parliament intended very carefully for that punctuation to be there in that form, and thereby they wanted you to take it into account in terms of the interpretation. They talk here separately about examples, and this is a good example here, but of what I was talking about before. That is italics, slightly smaller font. When I think of examples, I really think of notes, as I was saying before when we were talking about notes above. So they're not intended to be exhaustive. They're intended to give you some assistance in really working out not what the draftsperson meant, but what the Parliament or the legislature intended when they put in place this provision. It's interesting that they mention penalties here. I don't think of penalties as a intrinsic issue to be considered. I mean, penalties very much is the idea that when something creates a penalty, where it's disciplinary or criminal in nature, or it creates an offence, or it in some way takes away a right or punishes a member of society, that the court will be very restrictive or limited, or it will read down the way that provision is interpreted, because they're conscious that somebody's liberty, rights are at stake, and they want to be very clinical in the way they therefore interpret the provision. And if there's any grey area, it will favour the member of society, the member of the public. All right, so let's have a look at these questions. We might do what we did. We might do what we did last week, and I might trouble you to read through it, and we can talk about it together. Peter, do you want to do the first one for me, please?
Okay, so question 1. In what way does Section 13 of the Commonwealth Acts Interpretation Act assist with interpretation of Commonwealth legislation? A, it conforms with everything in an act that is part of the act. B, it confirms that most things within the act can be used for interpretation. C, it clarifies the use of an objects clause is appropriate for interpretation. Or D, it calls for the addition of, should be a definition section in legislation. And I think it was A.
Yep. I mean, C is okay. B is a little bit less okay. D is wrong. A is the best. Erin, please, number 2.
Sorry, Dominic, I don't have my notes with me. My internet's out of action, so I've got to go to somebody else's house to get online, and I can't find those week's notes. So, yeah, sorry, I haven't got anything in front of me.
No worries. Can you guys not see the screen?
Yep. Okay, so I'll read it from there.
Thank you. I was worried you haven't been able to see the screen. No. Thank you.
Question 2. What is the most prominently used way of describing the purpose of modern legislation? A, the long title. B, preamble. C, the objects clause. Or D, a short title?
Well, I mean, certainly, okay. Yep. What do you think?
I think no problem way of using just go. I would have thought the objects clause.
Definitely. I think certainly in Queensland, they use objects, an objects section, or a section as to the objects is the primary purpose stating section within the Act. Very, very rare to see a preamble. There is a long title. There's often a long title and or a short title section, or a long title and short title stated, but it's the objects clause. Melissa, please.
For what purpose did Justice Kirby use the long title and the short title of the Freedom of Information legislation in Ausland and Secretary to the Department of Justice? A, to determine if the preamble was still active. B, to work out the meaning of an undefined provision. C, to determine the public purpose of the Freedom of Information Act. Or D, to determine if the legislation was still in force. And I have C.
Yeah, so His Honour was using the titles of the Act to give as just one of the inputs into the purpose of the Act. And I think a good example of that was we were looking at the Australian Human Rights Commission Act. And that's, I think, if you think about that title, Australian Human Rights, as the sort of the second element, commission, so it's setting up a body to deal with human rights within the Australian jurisdiction, and it's doing it by virtue of this Act. I mean, that's an example, I think, of a very simple title that tells us so much about what that Act does and what it's intended to achieve as an example. And that's the sort of mechanism that Justice Kirby was using in that case. Jason, please.
Okay. What was one of the solutions used by the legislators not wanting to include long lists of items within the body of a piece of legislation, particularly where the list might change from time to time? A, using a long definition section. B, using schedules. C, including lengthy notes. Or D, providing examples only. And the answer is B.
Yeah, I mean, when I read this for the first time, my immediate reaction was to say either A or B. I mean, but long lists is they're actually stating, a list. So I think when I think of this, I don't know why I always think of tax stuff, but I think of the deductible gift recipient schedule, which is included in the tax legislation. So if you want, if you donate money to the Queensland Art Gallery, it's a deductible gift recipient. If you donate money to the Australian Red Cross Society, it's a deductible gift recipient. There's sections in the tax legislation which articulates how you determine whether an entity should be a deductible gift recipient, but in the end they put the entities in a schedule, and so it's absolutely clear, and that's what I thought of as I was thinking about this section. You could potentially do it in a definitional section, but that's not really the purpose. It's not listing off, Australian Red Cross Society, Queensland Art Gallery, Queensland Museum, Queensland State Library. It's more about that. That's the sort of thing you put in a schedule, as opposed to tax-exempt entities in a court. A deductible gift recipient definition is a tax-exempt entity in accordance with Division 50 of the 1997 Act, something like that, which would be a definition. Brad, can you do question 5, please?
Yep, sure. Question 5. What is the usual rule regarding the interpretation of a penalty provision in a criminal statute where a breach is said to be resulting liability to imprisonment for 10 years? A, this is the maximum period sentence. B, this is the minimum period of sentence. C, this sentence is mandatory. Or D, this sentence is the maximum unless stated otherwise in the Act.
Yeah, so you're looking at this phrase, resulting liability, or liability to imprisonment for 10 years. Liability to imprisonment for 10 years, it's a penalty. It's an act that'll take away someone's liberty, imprisoning them, incarcerating them. So if there was uncertainty about the meaning of liability, is that a minimum time, is it a maximum time? So the court will always interpret that in a way, if there is uncertainty, in a way that favours the person potentially incarcerated. So they're going to focus upon it being the maximum rather than the minimum, or rather than the mandatory. This is a really interesting area, I think, because, you've got places like, I think I'm right in saying that in New South Wales, you've now got some mandatory provisions, for example, where if you harm, I think, or if you unlawfully kill a police officer, it might be murder, a police officer, it's for your natural life. So it's actually a mandatory sentence, period. You might check that, but that's my recollection of it. So really here the example would be, unless it states specifically otherwise, that's going to be the maximum if you're talking about liability to imprisonment for 10 years. So to get around this, of course, they've had to try and amend a lot of the provisions to pick up these types of intricacies and to make sure if they're stating maximum or minimum or mandatory sentencing. It's not an area that I practice in, but I think it's very interesting looking at it from a statutory interpretation point of view. Libby, could you have a look at question 6, please?
Yep, sure. So question 6, section 15 AD of the Commonwealth Interpretation Legislation allows examples to be used for what purpose? A, to limit the operation of a provision. B, to ensure that the provision is not exhaustive. C, to extend the operation of a provision. Or D, to apply the usdem generis rule to Commonwealth legislation. And I was thinking C.
You know what I'm going to ask you next is why?
Okay.
Can you tell me why you think some of the others are right or wrong as well, please?
Okay. I would like to be able to read exactly what 15 AD, section 15 AD says, because from memory I had a look at that when I answered the question. Can you jog my memory at all?
That's good. That's a good way of doing it. Always ask me a question when I ask you a question. All right. So well, the Commonwealth. So think about what we've learned, what we've covered again tonight. What are the Commonwealth doing with their interpretation legislation? They're trying to ensure that everything in the Act is read, that in a lot of ways they've tried to simplify the interpretation mechanisms in the Commonwealth sphere. So they haven't tried to limit things, so I think we can rule out A. They're also not trying to make it more complicated, so they're not trying to create a non-exhaustive scenario. So, and you can see by the section number 15 AD that it's a section that's been added in relatively, when I say recently, relatively recently in the context that the Acts Interpretation Act is 1901. The Justum Generis rule to Commonwealth legislation, well, the rule's already there. They don't really need to apply it. It's already there. So really, even just without going and revisiting 15 AD, I think we can rule out, in a lot of ways, A, B, and D, and that sort of focuses us back onto C.
Yes, that makes sense. Thank you.
Don't worry. I don't. Most of the things I've said tonight, I can't construct a sentence. This is for everybody's benefit. As I said to you earlier, I'm finding it hard to. My brain's not at full tilt.
Well, thank you for that. Yeah, sorry.
Tawanda, could you take us through question 7, please?
Yes. When might it be appropriate to use an example in drafting of legislation? A, only in Commonwealth legislation. B, in state legislation. C, where the use of an example would aid in interpretation. D, when legislation is contemplated in a new area. I think the answer is C, where the use of an example would aid in interpretation.
Yeah, and I think it's funny how when I'm and you'll find the same thing, I'm sure, when I look at a section now, if it has a note or an example in it, that'll be the first thing I'll read. Because often the sections, you know, they seem to be, they feel long. You know, you sort of scroll down the page and you think, look how long this section has got, 7 or 8 subsections. And it's often the longest sections are the ones you're focusing on, because they're the ones that have been amended a few times, often because they're being used so often. And so the example becomes really important because it helps you. It's really helping in the interpretation process, and that, so see. Michael, please, could you do 8 for us?
Yep. Question 8. Where might we look to determine if part of a published act forms part of the legislation and can be used for interpretation purposes? A, the second reading speech. B, the explanatory memorandum. C, the interpretation legislation in your jurisdiction. Or D, the dictionary. And I said C, the interpretation legislation.
Yeah, definitely. So it's setting up the structure. The only other thing that comes to mind is, depending on what type of legislation it is, see, it might be a regulation, something like that. You might look at, you know, there might also be statutory rules or legislative drafting act. You just got to be careful. I mean, but it's definitely going to be in some type of other legislation which tells us about interpretation, however so titled, Interpretation Act. And they're given funny names. One of the things that strikes me is they're not all called Acts Interpretation Acts. They're called some funny names in some of the different, even in the different Australian jurisdictions. And that can make it hard sometimes.
Dominic, can I just ask a question there, please?
Of course.
You said it, you know, in the about if it's a regulation. Do regulations have the second reading speech and explanatory memorandum as well? Do they?
Not usually, because the regulations hang off the act, and because they hang off the act, and they exist only because the act exists, or they're linked to the act. It's the act that'll have the second reading speech and the explanatory memorandum normally. But sometimes, of course, the regulation might have its own second reading speech or have its own explanatory document. I mean, it's not. But I think the norm would be no, in a general sense.
Okay.
Josh, do you want to do 9, please?
I was hoping you were going to miss me tonight.
Yeah, you guys disappeared off the screen there. You're very unlucky.
What was that, mate?
I said you're very unlucky.
Must be, hey. What is the situation in the Commonwealth and Queensland regarding the suitability of using punctuation in statutory interpretation? A, both suggest punctuation is part of the Act. B, both suggest punctuation is part of all material and can be used. C, both jurisdictions prohibit reference to punctuation. D, both A and B are correct. I reckon it's D.
Yeah. And basically, the summary of it is the punctuation is in the Act and it's important. And you need to take it into account in interpreting the provision or the section or the subsection or the paragraph, or whatever you're looking at. All right.
So, Dominic, what happens then if the drafter has put a punctuation mark in an incorrect place? Because sometimes that can change the meaning of things, can't it? So what happens in that instance?
I think you need to interpret it on the basis that there was no error, and work on the assumption that that's Parliament's will or intention, and they passed that legislation, and good or bad, right or wrong, they put that punctuation mark in the wrong place, and that should be given effect. And if it changes the meaning, so be it. Unfortunately. I mean, I can't think of an example where a comma before a word rather than after a word might fundamentally change the meaning of that section, but I'm sure it could happen, and I'm sure there'll be an example out there somewhere. But I think it's a good point that you make, that it can have a real impact. When I think of that, I think of those will examples, because that's where you're seeing errors all the time. You think about the number of wills that are done within society. There just genuinely are errors in them, because there's just so many of them, and each individual person, people often change their own will. So in a lifetime, they may have 5 or 6 wills, and there are low-cost legal items, so people don't spend 50 hours on them. They spend 1 or 2 hours on them, and errors are made. And I think that's where you see punctuation in the wrong place, and it can have a really significant impact about how a clause in a will can be interpreted. And I think that's where your point's a really good one, that it can have a really significant impact. It may not have been the intended impact, but you have to work on the assumption that the testator of the will intended for that punctuation mark to be there, because they signed the will, in the presence of 2 witnesses, all persons having sound mind and body. And I think that's sort of a scenario that I've seen lots of times, but I'm sure your example or your scenario has occurred in the past where statutory materials have had those errors in them. Any other questions, guys?
Dominic, I have a question, which
Certainly.
I'm concerned may be a very basic question, but
There aren't. All questions are good questions, and there's no basic questions. Everything's hard. Everything's hard.
Okay.
And when I can't answer it, what you're really doing is you're going to make it really hard for me, because if I can't answer it now, you've said it's a really basic question.
Okay, sorry about that.
That's all right, I'm kidding.
I'm sure it's easy, but what I'm still confused by is the fact that we've got the modern approach to statutory interpretation.
Yes.
And then from reading different cases, it appears that certain judges at times choose to take the literal approach.
Yep.
And I'm wondering how they're able to do that when the statute is present, knowing that statutory law generally overrules common law.
Yep. So I mean, all they're probably saying, so without knowing the specific case or cases you've looked at, what I think they're really saying is, I'm reading a section, whatever the section is, I read through it, I say, what does it mean? I interpret the section. If I don't go anywhere else or think about anything else other than just the words in that section, fundamentally I'm just doing a literal rule approach. It's a plain English reading of the section in a literal sense, and I'm going to apply the facts to that section. The minute I think, I'm not certain about what that section means, the only course that I'm now supposed to take really is to think about the purpose, because I'm not certain from the plain meaning, the literal meaning of the words in the section, what it means. So I think that's probably what you would have seen in action in a series of cases. And potentially. Is that the sort of thing you've read?
It is, yes. And I mean, the wording that I read was that a judge was taking a literal approach, and I was just basically confused that that was an option for judges, that they had it appeared that they had a choice.
Almost like, well, why aren't they? Why isn't that judge only applying the purpose of the act as the mechanism for reading that section?
Yeah, or just the fact that there is the Acts Interpretation Act now, and that it includes a literal interpretation, but goes on to then enable a purposive approach as well. The fact that judges still tend to specify that they've taken a literal approach.
No, I think you've summarised it well in this sense. They're only what they are effectively saying is we only need to go through the process of interpretation when we can't work out what that section itself means. So we're only going to the Acts Interpretation Act or going through the process of interpretation when we're a bit uncertain or there's a bit of a grey area about how this section applies to our material facts or whatever it is. And so I think it's a good question, and hopefully that's an answer.
Yes, it is. So just to clarify, it is appropriate to say that they have used the literal approach in a discussion.
Yes.
Yes, thank you. That's great.
I mean, and they might describe it as the plain English reading, the literal reading, the literal rule. I don't think you'd see the literal rule, but you might see a plain reading of this section, a plain reading of the statute, or some sort of wording like that, maybe.
Thank you very much. That's fantastic.
No worries. All right. Well, I'm going to let you guys go. Well, please, and have a great Christmas. So as I said right at the start, the plan now, and I'm going to I'll mention this on the news forum, of course. Our next live session will be on the 8th. Between now and the 8th, I will record another session. For all intents and purposes, it'll be very similar to this session, but it will be just recorded, and then after that, we'll have our normal session on the 8th, and we'll go from there. Thanks very much. Have a good Christmas.
I wanted to ask him something.
You want to ask me something?
Yes, I did. You didn't hear me, did you?
Yeah, I did. I'm here.
Just about the stop laughing. Just with regards to the next assignment.
Yes.
Are you going to post anything about that as well? Because it's pretty much a long and involved task, and I'm just wondering just how far are we meant to go with it?
Yep. On the news forum, you might have seen already. There is a posting where I spoke about the second assignment. Have you seen that?
No, I haven't yet because I don't have an internet, so I'll have to check that out tonight before I go home. Thanks.
I did that maybe 2 Fridays ago. So just have a look at that as an initial thing. And of course, once you've had a look at that, drop me a line or we can talk further. There's no problems at all. But that's a good little sort of 5 or 10 minutes where I just talk about the first assignment. The second assignment, I'm sorry. Second assignment.
Okay, thanks.
No worries. Thanks very much.